Last week's Brandon's blog was advice for Ontario lawyers who are insolvent, how they can do an insolvency filing and still keep their law license and their livelihood and their profession. In this video, Brandon talks about how a CPA who is insolvent can do an insolvency filing and keep their CPA designation, their profession, and their livelihood. We cover the 15-day reporting clock for an insolvent Ontario CPA, how an Ontario CPA can keep his or her license and livelihood even if filing for bankruptcy, and what alternative there may be that is better than bankruptcy to eliminate the majority of an insolvent CPA's debt. I am Avatar Ira Smith, president of Ira Smith Trustee and Receiver Inc. Right now, Ira and Brandon Smith are helping consumers and entrepreneurs just like you to solve their debt problems. We are a true family business. We are not for everyone, but if we take you on as a client, we promise that you will be treated with the utmost of respect and that you will always deal with a licensed insolvency trustee, never a clerk or assistant. So, if you have any questions about this video or anything else, shoot us a message, give us a phone call. We would love to hear from you. I hope you can watch the rest of the video and you find the information helpful.
Okay, so if you're a chartered professional accountant facing serious debt, it's more than just a financial problem, right? It can feel like an absolute nightmare. We're talking about a high-stakes situation that threatens the very career you've poured your life into. So today, we're going to break down exactly how you can get through this, protect your license, and really find a clear path forward. And let's just call it what it is. It is terrifying. There's this huge sense of fear, maybe even shame, when you, a financial professional, are struggling with your own finances. But here's the most important thing I want you to hear right now. You're not alone in this, and this is absolutely not a career-ending event. So, let's start by tackling that biggest fear head-on. You know, a lot of CPAs try to hide their financial struggles because they think the consequences are just catastrophic. But that belief, it's usually based on a huge misunderstanding. And here it is, the number one myth that keeps so many CPAs stuck in fear. Let me be perfectly clear. Filing for a consumer proposal, or even for bankruptcy, does not mean you automatically lose your CPA designation. That is simply not true. The reality is way more nuanced, and it's a process you can absolutely get through successfully. Okay, so while your career isn't automatically over, there is one rule. One really important rule you cannot break. This is probably the most urgent, non-negotiable part of this whole thing. So what do you think? What is that one mistake that can cause the most damage? Here's a hint. It isn't filing for insolvency itself. It's something much simpler and way more dangerous if you ignore it. 15 days. That's it. That's your window. The single biggest mistake you can make is trying to hide your situation from the regulator. Being proactive, being transparent, that is step one to protecting everything you've worked for. And look, this isn't just a friendly suggestion. It's written right into your professional obligations. CPA Ontario Regulation 4.3. If you fail to notify them within that 15-day window, that's what's considered professional misconduct, and that creates a much bigger problem than the debt itself. So, complying isn't a sign of weakness, it's your first and most powerful strategic move. Okay, so you know you have to report it. The next logical question is, then what happens? What is CPA Ontario actually looking for? Once you understand their perspective, a lot of that fear starts to fade. This is absolutely crucial to understand. The regulator's main concern isn't that you're in debt, it's why you're in debt. They do something called a merits review to basically understand the story behind the numbers. And during this review, they're really just looking for ethical red flags. Was there any fraud? Did you mishandle client money? If the answer to those questions is a clear no, and your debt is because of, well, life, a tough divorce, a business that went under, a health crisis, the regulator is usually very reasonable. CPA Ontario gets it. They know that smart, capable people can just have some really bad luck. So this brings us to your options. Once you make that decision to act, you're looking at a choice between two main legal paths to get debt relief. You can think about it like this. A proposal is basically a structured, legally binding plan to repay a portion of what you owe. Bankruptcy, on the other hand, is about surrendering certain assets in exchange for having your debts wiped away. And for most professionals, one of these paths is usually a much better fit. Let's just break this down. The big one here is asset retention. With a proposal, you keep your assets. That's huge if you own a home or have a stake in a business. Plus, it just looks better to CPA Ontario because it shows you're making a good faith effort to repay. Bankruptcy, on the other hand, well, you can lose non-exempt assets, and it can definitely lead to a stricter review. And if you're worried about a proposal is some kind of weird, uncommon option, it's not. Just look at the numbers. 4 out of 5 consumer insolvencies in Ontario are proposals. It is the standard, powerful, and effective way for people to restructure their finances. Now, navigating this whole process, especially when your professional license is on the line, well, it's not something you should ever try to do alone. You need a strategic guide, an expert who really understands the unique pressures that a CPA is facing. And honestly, this might be the most important decision you make in this whole journey. Not all trustees have experience with these high-stakes professional cases. You need somebody who speaks your language, the language of finance, of CPA bylaws, and especially of complex CRA tax debt. And that's where expertise and empathy really have to meet. This quote from Brandon Smith at Iris Smith Trustee and Receiver Inc. just gets right to the heart of it. What you need is a confidential, completely non-judgmental space where you can solve this problem discreetly and effectively. So what does a real expert guide do? Well, it's way more than just filing paperwork. They help you draft that critical 15-day notice. They help you frame your story for the merits review so it's understood correctly. They handle all the complex moving parts. This kind of strategic approach is what ultimately protects your career. All right, let's bring this all home. Let's shift from the problem to the solution. Because the goal here isn't just to survive this. It's to actually regain control and start moving forward with real confidence. And getting started is actually way simpler than you might think. It really just boils down to 3 manageable steps. First, you just schedule a single confidential conversation. From there, you prepare your financial overview. And finally, you execute that notification strategy with your trustee right there with you. See? These are concrete actions that turn anxiety into a real plan. I really can't stress this enough. Waiting only makes things harder. Once creditors start coming after your wages or freezing your accounts, your options start to shrink fast. Making that proactive choice today, that is the most powerful thing you can do to put yourself back in the driver's seat. At the end of the day, this terrifying experience, it does not have to be the thing that defines your career. With the right strategy and the right guide, it can actually become the turning point, the moment you got your financial footing back and secured your professional future. So the only question left is, are you ready to take back control?